And we're live.
All right. Hey, hi, this is Curt Verone,
And
and go ahead, Brad.
and me, Brad Pinsky.
All right. And I have somehow lost my computer screen here, but all right. But at any rate,
I'm
and
good.
we're here for another edition of Fire Law Roundup for November 11th, but we're doing it on the 10th because both Brad and I are traveling tomorrow. So it is what it is. Let me see if I can get my screen back here. There we go. All right. My world is
Well,
back in kilter here.
so let's start in Miami. This is short, and I got to tell you, I don't totally understand all the facts, but there was an unauthorized training exercise, and the guy who I presume led it had decades of experience in the fire service. His son participated, who was 28. Now, he was not a firefighter, he was an EMT. It looks like they were at the training towers from what I could see. There were
I think it was
other
in a
fire.
quiet, I think it was in a quiet structure. And I think that might be the issue. Again, I haven't followed it closely, but I think it was in a quiet structure and they had permission to use it for overhaul and demolition and stuff. They didn't have a permission to do a live burn, and they were apparently doing a live burn.
Well, yeah, and as everyone, what is it, 1402, 1403, right? The live burn protocols. But in any event, unauthorized, and he was the son joined the father. Unfortunately, the son perished. So the news that you presented is three of the firefighters, including the father of the son who died, have all resigned. So, the lesson certainly, and I don't understand the cause of the death. I'm not, tried to look at the backstory. I didn't see it. But I don't know if it was from exhaustion or he fell or who knows.
I think
Do
it was
you,
burn injuries. I'm pretty sure it was burn injuries.
oh
Yeah.
boy. Okay. And,
Yeah.
and that's going to bring in probably
I'm
OSHA
saying
or,
that maybe I misspoke. I'm not sure. All I know is he was injured. He was severely injured on the day of the incident, and then he passed away the next day. So maybe it was, but the
yeah.
bottom
And look,
line
you
is,
can I hate to sound this way, right? So everyone please excuse me, but the I hate this that I'm going to say this, but the interesting part of this will be what happens after. Who sues? Right now, clearly you're going to get probably OSHA and NIOSH or whatever else in here, right? Or state coming in. Florida is a somewhat PESH state or OSHA state.
yeah.
So it's somewhat voluntary, somewhat not. In any event, there's investigations going on, of course. But on the legal side, would there be a lawsuit? Who would sue? Right? The
Well,
mother, if
and
there's a
that
mother.
is an interesting. I was actually thinking about that. So who? Go ahead. Go ahead.
Look, it could be a wife if the 28-year-old was married. It could be
Mhm.
children if they have children. It could be the mother could sue the father, but you'd ultimately be suing the department for the negligence of the person's father. The father, and here's always what the problem is. The father, if he wants justice done, meaning money for, let's assume for the moment, and I don't know this to be true, that the son was actually married with kids, maybe no life insurance, whatever. The father's now in the position of saying, yup, I was totally at fault, it's my fault, and my employer should pay for my act, for my negligence. I mean, that's the situation the father could be putting the department in.
Mhm.
So very, and I don't know, I'm guessing.
Yeah, I am too. And I did while you were talking, I did research it. He passed away of from what the CBS News in Miami said was smoke inhalation. So
Yeah, so
again, when I'll quote from CBS News, when first responders arrived, they found 28-year-old Fabian Camaro in extremely critical condition with smoke inhalation.
And so that begs the question, is this another Lairdsville incident back to 2002 where they used a
Yeah.
victim, right? And somebody who had no SCBA training. So did they use a live victim? We don't know, right? So
Right,
I'm
and
not even going to
I'm
guess
sure
anymore.
we'll figure it out. But I think,
Yeah.
it's one of those things. The investigation appears to be proceeding slowly, which, you know, I
Hopefully
understand
methodically.
the need to do that, but at the same time, there's lessons learned, and we certainly want to try to get those and get those out. But at any rate, three of the people involved have resigned, and that could be an indication that they're getting ready to release the investigative report. So,
All right. So obviously our sympathies with everyone, but okay, let's go to Oregon. This is a really quick one. This has an interesting lesson. I don't know if my lesson will be the same as you will present, but look, we got a bicyclist who claims that the Columbia River Fire and Rescue was, I don't know if they were even responding to a call, but in any event, they took a right turn, allegedly. This is just a lawsuit. We don't have facts. Allegedly took a right turn and cut off the biker, injuring the biker, causing damage to the bicyclist, not motorcyclist, but bicyclist. The bicyclist was 71 years old. And by the way, this happened back in 22. But the funny thing is, they sent him a bill for the ambulance treatment, right? So he's cut off, he's transported, but he's transported now by the vehicle or treated by the vehicle who cut him off, caused the injuries, which in a lot of states, by the way, is the law. If you cause injuries, you now have a duty of care. Even in, for example, New York, where there's no duty of care, you have one when you cause the injury. Right. So in any event, they treat them, but then they send them a bill. Probably not the best move, probably an oversight. But, if we've allegedly caused injuries to people, let's not send them a bill for the treatment.
We learn that as lawyers, and they say, well, one of the best ways, one of the easiest ways to get sued for malpractice is suing a client because they didn't pay the bill.
True.
Right. True. And because they're going to have to go to a lawyer, and then at that point, they're going to find something that you did wrong. And so one of the easiest ways to get yourself in a malpractice action is to sue a client for fees. Yep. Not identical here, but when you bill someone that you were responsible, or maybe they were, and I think this may be a factual question about whether or not the bicyclist should have, if the vehicle was in front of the bicyclist, taken a right. It's up to the bicyclist to, be observant for the vehicle turning. It's just like any other vehicle on the road. If you're passing on the right and you take, so at any rate, there's a factual question, I think, there. But
and one of the things that's not reported, I didn't see, so I assume it wasn't the case, is were they responding to a call? Did they have lights and sirens on?
That's another aspect of it. But here's my question. The principle, I think, is when you cause someone's injury, whether you're a lawyer or an ambulance or a fire department, whatever, you cause somebody injury, don't add salt to the wound by suing. But
right.
This is right up your alley with regard to EMS work. What does Medicare and Medicaid say about billing? My understanding, and it's limited, I'm more fire than EMS, but my understanding is that if you're going to bill, you have to bill everyone. You don't have to collect from everyone, but you have to bill everyone. Can you forego billing people and not lose the ability to charge Medicare and Medicaid?
Yes, because Medicare doesn't use a one and done type rule. Medicare is you are entitled to bill somebody for the lower of your average collectible rates or the Medicare fee schedule. So here, if you routinely waive fees, your average fee is going to come down, but waiving one or two is never going to affect something of this size, right? Is never going to affect somebody's average billing rates. But, if you routinely waive them, whole different topic, then you really could be affecting your average rates.
Okay.
So, but you're right. Don't send a bill.
Yeah.
Okay, so let's okay, so there are remaining three are really interesting. One's a little easy, but are really, really interesting. So we kind of wanted to get past the first two timely. So now we're going to go to Massachusetts, where the Massachusetts Court of Appeals upheld a fire commissioner's determination to bypass the promotion of a fire captain district chief. There were three lower ranked candidates who received it. And the reason this is so important is because for anybody who is going to do interview and promotions, the court provides you a checklist of the best practices. And that's what I want to look. I'll point to the case is good because, right, it's interesting. Can you choose somebody lower on a list or with lower, rank or whatever? And of course you can if you have substantial good non-biased reason. The captain says, listen, the only reason I wasn't chosen was because of a personal grudge and gripe. But let's look at the process that the department used, because this is such a good checklist for anybody who wants to know how to do interviews. So the standard is first that a bypass decision, and frankly any hiring decision in this case, is reasonably justified when it's made with, and this is a quote, adequate reasons sufficiently supported by credible evidence when weighed by unprejudiced mind, guided by common sense and by correct rules of law. So basically, would a reasonable person believe that this was a well-supported decision that was basically not biased on prejudice? And here, listen to what they did. So the commission concludes that the process used was reasonably fair and not overly subjective or arbitrary. The interviewees, the interviews had 10 questions. They were all asked the identical 10 questions. And so that's step one. Everyone's asked identical questions. I'm presuming there were no follow-up questions, because that's all often where many interviews get in trouble. They stray from the list of standard questions in response to something that's said. And the questions which were standard were deemed to be appropriately, or they had appropriate inquiry into qualities that would be important to a district fire chief, right? So it's not like, are you married? It's not like, hey, have you ever played golf and you like to play, who's your favorite football team, right? They focused on qualities that were important to a fire chief. And they then score those questions. And extremely important here is that those who conducted the interview were completely unbiased. They were professionals. They were not really linked with this person in any way. So it was a very good unbiased set of questions asked by an unbiased panel. And the commission and then the court finds that the city looked at the candidates, all of them, their examination scores, their education, their experience, their relevant professional qualities. So to me, this is what you want to do. Now, they didn't talk about scoring sheets, but there should be scoring sheets created in advance of the process that are reviewed to make sure they're unbiased and not, set towards any certain candidate. And on top of this, what then the court says is, and the commission found, is that any biased, right? There was no bias they found. It was more of perception, right? Rather than truth. So Curt, I just thought this was a great how-to, right? On a very high level view, how to conduct a promotional process.
Yeah, Massachusetts has this statewide civil service system that oversees hiring and promotions and certain parts of discipline and so on. And so these 6 candidates all qualified as capable of being district chiefs. And, he was ranked 3. But you're right, in the civil service system allowed the local fire department to go beyond that, to just evaluate the candidates, beyond what the civil service written exam had ranked them. And the firefighter, I think, the captain who got passed over, took issue with it, but the department did it right. And one of the comments I would add to this, just from personal experience, they had a numerical rating system for those 10 questions. I was involved in an assessment center in Connecticut, where I was one of the people asking the questions and doing that. And I actually did it a couple of times for the same department, but it was overseen by a clinical or a research or educational psychologist, guy with a PhD on education. And when we sat down to sort of organize it, his recommendation was that everyone was ranked either 1 or 0. 1 or 0. No 1 to 10, 1 or 0. They either pass or they don't. That's it. And that way it eliminates the bias. And we push back. So not so much me, I was just kind of observing, but some of the other chiefs that were on the committee pushed back, and he allowed them to go to, I think it was 0 to 2. So if somebody really did well, you could go to 2, but that was only after pushing back. But the psychologist's reasoning was that the more numbers you add in there, the more arbitrariness comes in.
Yeah.
And that the person either answers the question adequately or they don't. And 0 and 1 would be a better, it's more defensible for him as an expert. We don't usually think about it from that perspective, but as an expert witness, the system is more defensible when it's 0 or 1, or even 1, 2, or 3. When you start getting into 7, 8, 9, 10, especially when you've got a number of candidates and you interview somebody Monday morning and then somebody else Wednesday afternoon, how do you keep the same scoring?
Right.
It's difficult. Whereas with 0 and 1, you either answer the question, some might have done a really good job, some might not have. So in this case, there were 2 questions, and the case, for those of you who are interested factually in what happened, the case explains what the 2 questions were. And I think you can agree, you can understand why he didn't get a good grade, the way that he had answered them. So it doesn't seem to me to have been arbitrary.
Yeah, and I got to say, I like the 0, 1, 2. In 0, not acceptable, 2, best answer, 1, okay, acceptable, right? And I agree. You put a 3, 4 in it, and it really does add subjectivity. The reason I think a 1 is important, or a 1 and a 2 are important, is because here you have some tactical questions. So, do you save a life? Do you save a life the best way? Was it an okay way to fire? Was there a best way to fight the fire? And so I don't know really, how much leeway there was in any of those answers, but it seems to me 0, 1, 2 is better. And I agree that with, the person you quote, you start putting more into that. You really are how do you differ between a 3 and a 4? Right.
That's it. And are you consistent? I mean, and I said, yeah, fine. This was like a 3-day assessment center. It was for promotions, for lieutenants and captains. So it was a bunch of different stations that we did. The psychologist was absolutely right, because you're doing it Monday morning, and you're grading people. Are you doing it the same way Wednesday afternoon? And you can't. You're not. You can't possibly do it the same way,
right?
Because you've heard some answers and so on. So I've sort of come around to appreciate that psychologist's approach.
Yeah, I agree. I think it's right, and it's a science, right? And I'll end with this, and you and I have made this comment many times. The layperson does not create exams, right? These are professionally created exams. You will always have an expert. If you're not an expert, you will have an expert. Plug holes, find bias, find questionability, right? They will destroy your questions unless you have vetted questions, tests, whatever, that have been used by other departments and approved. You're literally playing with fire when you just make up your own, in my opinion.
Yeah, I agree.
Okay, let's go to West Virginia. So I'm hoping I put a spin on this that you didn't think of. Normally, that's not the case. But here we have a civil service commission who upholds the termination of a fire chief in West Virginia. Now, the West Virginia chief is accused of allowing 1 or 2 Fair Labor Standards Act overtime violations.
Not allowing. He was a plaintiff. He was a plaintiff in the cases.
Shoot. Okay.
Yeah. We covered this.
Yes.
Every single firefighter in this fire department joined a FLSA suit, and they file under federal law in the federal court for the FLSA, and they file state court under state law wage and hour claims. So there was 2 lawsuits, but he was a plaintiff in the suit, and he's the fire chief. And I'm assuming he's claiming that when he was a firefighter, or when he was prior to becoming the chief, he had been not properly compensated.
Okay. So now it makes a little more sense. And by the way, just a quick note, sorry, viewers, your link on here's our earlier coverage doesn't work.
Okay. I'll fix that.
So he's terminated because he has a mural in his office. So obviously the question is, is this, just a fictional reason that you're not allowed to have a mural? But because I'm kind of saying, like, when did you discover the mural? And I'm sure, right? How long has it been there? And really, termination is the punishment for you put a mural. I'm thinking like freedom of expression or something, right? But nonetheless, maybe what are they going to say? You vandalized the office, your office by painting a mural on your wall.
Well, they say when they want to get you, you'll have a spot on your uniform, your tie was crooked. When they want to get you, they'll find something. And the question is, are you going to be able
Timing.
to overcome the presumption here? It looks like there should be a presumption that this was retaliation.
Oh my God, the timing, right? It's always timing, as far as I'm concerned. Now, here's the thing though, right? This I don't know how long the mural's been up and whether he was warned or told to take it down, right? I don't have that information. But let's create the time if we can, if when was the suit which he was a plaintiff in, or the complaint?
Mhm.
Right. So, and then if that's 2 years ago.
No, it was June of this year, I
Oh,
think.
no. I'm just saying, if it's 2 years ago and okay, the mural comes up now, well, it's hard to link. If it's just as it is in June and he's just terminated thereafter, okay, that's a little close in time for something like this. So I don't really care that the Civil Service Commission upholds the termination. That doesn't bind a court if this chief sues. And, just my mile high view here, it looks a little sketchy.
That's where I'm at. I'm, whatever. Maybe they've got an excuse. Maybe this was just such an outrageous mural that even if he had filed legitimate FLSA suits, it still warrants termination. But I'll tell you, the timing, not always, but timing with regard to retaliation suits is really.
And I want to know what the mural's of. Is this like a 9/11 mural? Is this, a firefighter mural, or is this a naked woman mural, which I presume it's not, right? But I'm making that up. But it seems pretty thin as far as I guess you and I can tell. And if anybody has information on what this mural was, and whether did he get warnings? Was he warned a number of times? Right? Was he told to take it down? Did prior chiefs have the same mural? Did he paint the mural? Was it a hanging mural, or was it painted on the wall? I mean, there's so many questions you can ask on how realistic is the reason for their termination. So, okay, in that case, then we end up in LA County, I believe, for our fifth and final. Let me start here. If this is true, this will result in a very significant multi-million-dollar settlement or verdict. This is not going to be a cheap issue. This, if it's true, is horrendous. And I'm only going to pull out some of these facts. I really encourage all the viewers, listeners, to read your blog on this, because it is long and lengthy, and it is a continuous, I'll give you the overview, but it is a continuous list of unbelievable, egregious, alleged, really just discrimination and assault and harassment.
Well, before you get it, let me speak to the other side of this, because I have some friends that are high up in the LA County Fire Department. I find it hard to believe that they would have tolerated this and looked the other way at this had they been aware of it. So there's two sides to it. I do want to get that out there. There's some very as competent leaders as there are in the fire service. Many of the chiefs up in the higher ups at LA County would be there. And so again, I think you've got to kind of look at this. I look at it skeptically, and I laid out all the facts, because the facts, I think, are really, maybe this isn't that legitimate a case. Maybe it is. The facts, though, outside of my understanding of the LA County Fire Department and how they deal with things, these allegations are bordering on scandalous, that this should have been addressed. Okay, so
If
which
true.
leads me to wonder whether or not they are valid, or whether or not, maybe they're not quite what is alleged. And I don't know, but I think we want to go into this eyes wide open. So go ahead.
No, so and by the way, where I'm going to start it is not where I thought this case was going. I thought we were finally going to have a service dog case, and I'll share my opinion because you know it, but people don't know it.
He missed the statute of limitations on that one.
Oh,
So
is that what it was?
no, I don't know, but I'm
Oh,
assuming
okay.
that's why he could have. Yeah, but go
I
ahead.
thought that's where we're going. Okay, so here's what happened. So in August of 17, the plaintiff, the person suing, right, he was exposed to, and throw in allegedly to all of this, right? Because this is a lawsuit. These are allegations. This is not a court decision or a finding of fact. So this, I can't keep saying allegedly enough, but allegedly. So in August of 17, the plaintiff is exposed to toxic smoke and benzene while a firefighter. This leads to a bad diagnostic of aplastic anemia, which is a life-threatening disorder that affects his ability to produce new blood cells. So he undergoes various treatments. He has a bone marrow transplant in 18. He has to take 20 months of medical leave. So right off the bat, assuming this is true, everyone, we feel very badly that as a result of his service, he's severely disabled or injured. So he then comes back to work in 19. He's assigned to a firefighter / deckhand position. Think boat, I presume, because it's at Marina del Rey, where I used to go when I used to live in Santa Monica. He's the doctor. I don't understand this, I will tell you, but because of the severity of his condition, the doctor gives him a service dog to help manage his medical needs. And to start, what the plaintiff claims is, instead of accommodating this legitimate request, the department, quote, and I'm quoting, prematurely transfers him to another fire station without prior notice. Now, I want to stop here, right? And I don't want to make this a service dog thing, but it's a service dog thing to start. So my interpretation, and I believe I stand on solid ground reading the regs. Listen, the federal regulations require that if you're going to have a service dog, the service dog is always under the owner's control, which does not mean that you're sticking him in a cage when you go out on a call. So right off the bat, I'm having a hard time following why this decision was made to allow a firefighter, unless their desk, just set to the desk, how you accommodate a firefighter. I suppose, well, you can't accommodate them under federal law by allowing them to go on a call. That's my interpretation of federal law. I have not found cases, but I can read the regs. It always has to be under the handler's control, and that doesn't mean you stick them in a cage when you're out on a call, because that call could be 12, 24 hours, right? In any event, that's the service dog issue. It never kind of arises again, as far as I can tell, but then the harassment really starts. And what happens, let me summarize this. In 21, this new firefighter joins the station. He's allegedly very disruptive, very anti-gay, very anti-everything, and just starts a continuous onslaught, allegedly, against this individual who is not gay, but has gay relatives. And there are two other openly gay individuals, interestingly, who are not plaintiffs to this at the station, but allegedly this person is making horrible comments, very slanderous comments, homophobic, anti-gay comments. And the problem also is that it's done, and some of these are done in the presence of a captain who allegedly does nothing about it, right? And the guy saying, oh, if you really had cancer, right? He's questioning his cancer diagnosis. I mean, this is one of the most, if true, horrendous things we've ever seen, which is, I presume, Curt, is what leads to your, I can't believe this, right?
Well, yeah.
Can't be true.
And again, your comments right from the canine issue and accommodating that right on through, kind of, I don't know.
It's hard to believe.
It is. It is. And especially when the solution seems to be pretty obvious. I mean,
Right, transfer them.
You have one particular employee who's picking on this poor, innocent cancer survivor. It would seem to be it's a no-brainer. Just deal with this the person who's creating it. So that,
Right.
and again, some little backwater fire department that doesn't have strong leadership, you say, okay, that they don't know what to do with it. LA County, I don't
Yeah.
know. I
And
don't know.
it's interesting because and you and I have seen this many, many times. It's a very good ploy to do it. But what you say is, listen, everybody witnessed it, but no one, which he says, so many people witnessed it. It happened at a meeting where, the guy received hardly any discipline. He was berating me and others in front of a captain, in front of other people. But nobody's going to speak out because of the code of silence, right? And no one's going to come forward. So you've created the possibility that, okay, I'm going to tell a jury that the reason you're not going to hear from all the other witnesses is because nobody, right? That's not what we do in the fire service. And I got a hard time that your two other openly gay people are going to tolerate this. So I'm having a hard time believing it, but I don't want to criticize the plaintiff, right?
Right.
If I was a
Right.
jury, I'd have
And
to
I
hear
don't
a
either
lot of it.
because again, just like, we go back to you and I are at a Red Sox Yankee game and you see a play as out, the Red Sox player is out. I see the Red Sox player say two people can see the exact same thing happen and interpret it differently based on their biases and other things going on in their life. And so you don't want to dump on the plaintiff in this case, but there is objective reality as well. And objective reality doesn't necessarily align with someone's perspective about what they've been through.
Right, but
And
these are a
so
lot of
again,
incidents, and the one thing
there are
that gives me
absolutely,
pause, right?
absolutely.
There's one thing he's assigned to a boat, and the chief, I think of the boat, removes the allegedly harassing individual, removes them from that, which is all they had to do at the beginning, right? If
Right.
they just did it, but the fact this individual's removed now, we don't know why necessarily they were removed, but the allegation is, look, he kept doing it. Finally, somebody stood up and they give praise to that person, the chief, I think, and say, that I think it was a female chief, removed the person from the boat and now separated us. So that gives you some belief. However, the chief may come forward and say, yeah, but that's not why I did it. Or, I never witnessed anything. I just wasn't going to, even risk it. Who knows? We don't know. But this is going to be a law. This is why lawsuits become very expensive, because you're deposing easily 10, 15 people, right? And you're trying to prove a case to facts. And this is either a case you settle or you don't. And you're risking a jury, right, believing the person, but then you get well, wait a minute. Look at all these other times we've had these incidents. We've addressed them immediately, properly. How could this ever continue? I don't know. I would not want either side of this case as an attorney.
Yeah, no, me neither. And there's another factor. I don't know if it's applicable in this case, but we've seen it in numerous cases. I've seen it personally where you have a high-performing employee and a low-performing employee, and the high-performing employee is accused of picking on the low-performing employee, and the department looks at it. They don't articulate it that way, but in reality, you've got somebody who's doing everything you need them to do. They're a great employee. You got somebody else who's just doing the bare minimum, if even that. And how much of that is in play as well. That's
Yeah.
a concern I would have just looking at this, whether or not that's applicable here.
Right. And look, it's tough. You get a written complaint and you got to react to the written complaint. And there was a written complaint at some point. And was it investigated? What did they
And that's it.
see?
And right, so many departments don't do that. That they when you get a complaint, you've got to investigate it. And if it's unfounded, then that's fine. If
Right.
it's somebody's imagination, they saw somebody safe and they were really out, and the rest of the world saw them as out or safe, that's fine. But you do the investigation. You don't ignore it.
And one of these was at a meeting where it sounds like there's 5 or 6 other people, including rank, all right, not just file. And so the question is, did anybody ask? Because apparently nothing happens after that meeting where he's berating them. He gets minorly disciplined, allegedly. So what was said and who came forward and did they come forward? I just have a hard time believing nobody's going to speak up. LA is a progressive area. Maybe if we
They
were
really
in
are.
another
That's why
state.
I just find, were the things done wrong? Maybe, yeah. But I don't know, just the level of abuse that is alleged
Unbelievable.
is shocking.
Right.
Is shocking. So that causes me to pause. But if it happened the way that it's alleged in the complaint, like you said before, if they've got some questions to answer.
Yeah. And look, one thing that would prevent this is documentation, right? And who documented what when it happened, who was interviewed, who complained, and
Well,
so
in my discipline class, we talk about, do you have to investigate every allegation? What if somebody's filed like multiple complaints?
yeah,
You investigate every one of them. And if
yeah,
they're unfounded, your conclusion is they're unfounded. And now, once someone has made a number of unfounded allegations, that's all on the record, you're in a position now to do what you need to do about somebody who's filing unfounded complaints.
boy who cried wolf.
But you don't just ignore someone because you think they're filing another unfounded complaint. You investigate them all.
Right.
It's more work, but it's the right way to handle it.
Right. And we don't. Typically, we don't. Listen, I've even given advice after like the fifth, sixth, seventh complaint. Like, okay, what are we supposed to do? They keep filing complaints. None of them are founded. Well, you know what? We'll do the statute of limitations, right? The statutes may be 4 years. The problem with discrimination, when your complaints are of discrimination, you're not dealing with a 4-month statute. In New York, you could have a 4-month statute. But for discrimination, you're at 1 year to 3 years.
No, you have that continuous harassment rule, which
yeah.
Yeah.
So it's not each event that expires. So yeah, these are tough. But listen, fire chiefs, you should not ever. I say this to the chiefs who are listening, and I hope we have administration who listens and watches. You should never put the chiefs or the captains in the position where they have to make the decision how to react. There should be clear policy. Everything gets investigated. There's a written decision or something, but it's done neutrally. And then, but you shouldn't ask the chief, well, how do you want to handle it? There's no how do you want to handle it. Right.
Yeah,
this is how it happens.
One more aspect to this that may be playing a role, I'm not sure, is HR has a basic HR doctrine that discipline is between the employee and the employer, and no one else, even the complainant, needs to know about it. And this could be a problem that is actually a function of that, because the kid who's allegedly the perpetrator might have received numerous reprimands, maybe some suspensions and everything. But if the department doesn't at least let the complainant know that it's been addressed, then you have this perception that they're not doing anything when in fact they have done something.
So if people are wondering, so then what's the answer? The answer is you let them know it's been addressed. You don't have to let them know how.
Exactly.
Right? It's not, are you satisfied with how we did it? We did it how we did it, but we've dealt with it. If it happens again, you let us know.
Right. And HR has to realize, I mean, we're not cubicle world. In the firehouse, we're not cubicle world. When someone does something wrong in front of a bunch of other people and there's no tangible outcome, it's
you set a precedent that we don't do anything.
Right.
Yeah.
Right. So.
Okay. That's us.
All right. Well, that's going to do it for another edition of Fire Law Roundup. Sorry for the hiccups at the beginning there. And we'll see everyone again. This one will be for November 11th. We'll see you again in a week. That'll be, I think, the 18th.
Absolutely.
All right, man.